Hello and welcome to the Hindu. From today, that is July 1st, our existing criminal justice system has witnessed a complete overhaul with the introduction of three new criminal laws which are set to replace British era penal codes. These laws, which have come into effect today, are the Bharatiya Nyaya Sanhita or the BNS that has replaced the erstwhile Indian Penal Code, the Bharatiya Nagarik Suraksha Sanhita or the BNSS that has substituted the Code of Criminal Procedure, and the Bharatiya Saksha Adhiniyam or the BSA that will replace the Indian Evidence Act. However, right from the start, these laws have stirred controversy, with legal experts as well as jurists questioning the lack of transparency in the functioning of the five-member expert committee constituted by the Ministry of Home Affairs to draft these laws. They have also flagged how the new laws confer extraordinary powers upon police authorities at the expense of civil liberties. In fact, a petition is pending before the Supreme Court seeking a stay on the implementation of these laws on the ground that they were passed in the Parliament without any effective discussion, as close to 114 opposition leaders were suspended. To discuss these new provisions in detail as well as their potential implications, we have with us today Supreme Court Advocate Nipun Saxena. Welcome to the Hindu, Mr. Saxena. Thank you for joining us today.
Thank you so much, Aaratrika, for having me.
My pleasure. Now, before we move on to the substantive provisions of the new laws, I think it will be beneficial for our viewers if you could talk a little about how these laws will exactly be implemented. While the laws stipulate that criminal proceedings which are pending before the new laws come into force on July 1st will continue to be governed by the old laws, how does this exactly operate in practice? For instance, if the investigation in a case has concluded before July 1st, but the trial is yet to begin, will the framing of charges, the trial, and the appeal then proceed under the CRPC or the BNSS?
You have really hit the nail with that question. But for the viewers, since I am running under the assumption that a majority of the viewers will not be that savvy with the law, so let's take a step back and give a context of what we are really talking about. Now, when it comes to which law will come into force from the 1st of July, you have to look at two things. There are three different kinds of laws which are coming into force from 1st July. One, which is what you call the substantive law. What is substantive law? A law which defines the offense and makes it punishable. Right? Say theft hitherto was defined under a particular provision and it was made punishable under a different provision. Right? Now, that's substantive law. The second part is what you call the procedural law. Now, procedural law is the law which will govern every single incident or the entire journey of the case, say from the point an FIR is registered till the point where a person is pronounced guilty or innocent of the charges, and also may include appeals, revisions, and so on and so forth. Right. There is a third part which is called evidence, right, which also will apply from 1st of July, a new law which is the Bharatiya Saksha Adhiniyam, which will come into picture. Right? Now, it will also modify different forms of evidence. In fact, the very definition of primary evidence has been changed under the Bharatiya Saksha Adhiniyam. Right? So, one of the basic principles of substantive law is that the substantive offense will only come into being, or the substantive law will operate prospectively, meaning if a new offense is registered on and from 1st of July, then it will only be made punishable if the offense was committed after 1st July. So suppose if an act was not an offense under the old law but is defined as an offense under the new law, then the new substantive law will only govern on and from 1st July. Right? The problem starts with the procedure, which you have just mentioned in your example. You said that suppose if the investigation was completed before 1st July, but the
Right,
trial is yet to begin from the 1st of July, what happens?
right,
Procedural law, in terms of the Supreme Court judgments, can also apply retrospectively. right? So now this is the part, or this is the portion where a lot of confusion is going to be created, because the procedural law will continue or may continue to apply. The point where it may continue to apply is when CRPC was applicable. In
Right.
some cases, even when BNSS is applicable. So let's say, for instance, under the repeals and savings provision, which is 531, section 531 of the Bharatiya Nagrik Suraksha Sanhita, BNSS, it specifically says that if there was any application or if an investigation, trial or inquiry or appeal which was pending on and from 1st of July, then it will continue to be governed under the CRPC.
Hmm.
But Aaratrika, when you say that the investigation is completed, but now
Right.
trial has to begin, so
Hmm.
technically investigation was completed under the CRPC, but trial will begin under BNSS. So there are two
Right.
schools of thought now.
Hmm.
Whether one one court may hold that no, for the purposes of trial, since it's a new stage, it will be governed under BNSS.
Hmm.
Whereas somebody might want to say that since retrospectively procedural laws can also apply, therefore trial is nothing but continuation of an investigation. If
Hmm.
somebody is prima facie found guilty, therefore framing of charge, whether somebody's discharge application has to be moved or not, right, or any subsequent revisions, etc., arising out of that discharge, right, or evidence of the taking testimonies, etc., they will be governed under the old CRPC. So this really is going to cause confusion. What will apply? Because the repeals provision, which usually in any law, a repeals and savings provision tells which law has come to an end and which law will now begin. Right? In
Hmm.
an ideal world, the CRPC ceases to exist after 1st July, and BNSS comes from 1st July. No problem in that, uh, you know. But the Indian trials are not like that.
Right.
Indian trials go on for years and years altogether. Therefore, there may be portions of the trial that may have been completed on or before 1st of July, but there are certain portions which may continue. So this is precisely what is going to cause a lot of problem. Also, let me give you another example. Suppose police custody under section 167 erstwhile of CRPC was
Hmm.
only limited to 15 days. But now under section 187, that police custody can now go up to 60 days or 90 days, because the proviso which says not being police custody, that has been omitted under the new law. So now does it mean that that police custody which has not come to an end, suppose it was only the 14th day on the 1st of July, tomorrow on 2nd of July the police may make an application and say, look, we need more custody because the new BNSS gives her more custody powers. So this really is going to create a lot of confusion, and you will see across India there's going to be different trial courts holding different views, and all of that will be subject matter of challenge before high courts, and it is only going to increase litigation.
Right, right, sir. Well said. And of course, we will require clarity from the superior courts on this. There's, like you said, there's bound to be a lot of confusion. In fact, addressing this particular point, do you believe that corresponding changes in institutional capacity to implement these laws have been made? For instance, experts have pointed out that there has been no reliable and independent assessment of institutional preparedness, which is bound to maybe have an adverse effect on the pendency of cases.
Well, institutional capacity building is something which takes years and years. Just to give you a very simple example, when CRPC 1973 came into picture, it was not that it was dropped out of thin air. The first law commission which actually sat down to discuss and sort of look into the CRPC and its provisions, because the erstwhile CRPC was the British era CRPC was 1894. Thereafter, when India gained independence in 1947, in 1961 there was a law commission report. The 31st, 32nd, 35th, 37th law commissions actually sat down on every provision and decolonialized that particular aspect, right? So it
Right,
took close to 13 years and six law commission reports to bring the CRPC in its present form. Now, what have we done with the new laws? These new laws were passed on the last week of December of 2023, and thereafter the SOPs, which is the standard operating procedures of evidence collection, etc., were just released 2 days back. So, do
Right.
you think there was any meaningful time to train these police officers? And we are not talking about the tech savvy police officers of Mumbai or Delhi or Bangalore or Hyderabad or Chennai, right? We are talking about those 731 districts. Each district has minimum 10 to 20 thanas or police stations. Some of these police stations are located in rural areas. Now, let me just give you an example. There is a particular provision under the BNSS which is called Section 176, Subclause 3. It introduces a very laudable concept on the face of it. But if you look at it from the lens of institutional preparedness, you would see what disaster it is. Now, 176 subclause 3 says for any offense which is for which the punishment is over 7 years, then there has to be a forensic expert which will go for the purposes of evidence collection and not regular police force, which is very good. You see, somebody who has to take soil profile, to have to examine blood samples, chemical analysis, etc. It's best that a forensic expert goes so that contamination can be curbed, so that there is no foul play, etc. Right? Very good. But it says the state government shall issue notification in the next 5 years to bring these forensic experts on ground. So, what does it tell us? It tells us A, there is no forensic expert, as many forensic experts as may be required for the purposes of their deployment, for the purposes of, to carry out that evidence gathering. Number two, we don't even know how many of these forensic experts will be stationed in Dehat Thanas and rural Thanas all over the country. It is not that crime is not going to take place in the next 5 years.
Hmm.
Right. Crime will continue to take place. It's not like murders will stop in villages, or
Yes.
previous hurt will stop, or rape or sexual assault or any other forms, robbery, dacoity, etc. All of those will continue unabated. But since Section 176 subclause 3 clearly says that it has to be a forensic expert which has to go to the scene, where is that forensic expert? Do we have sufficient number of forensic experts? in
Right.
in the times that we have lived, Aratrika, you would see that as criminal law practitioners,
Hmm.
forensic science lab reports are the last to arrive.
Yeah. And most
Sometimes
scrutinized.
Absolutely. Sometimes they take 7 years, sometimes they take 10 years. Many a times the prosecution evidence is closed. The defense case statements are taken. 313 is taken, and thereafter defense witnesses are examined. Then somebody comes up and says, "Oh, look, but here's a supplementary charge sheet now saying that somebody has to be examined. A forensic report is there." So, when your regular forensic reports are taking so long, do you think that these forensic experts will be able to go to the crime scene, collect, and then prepare a report and bring it back? Especially now that there are specific timelines within which police has to complete its investigation. It is going to be very, very problematic.
Hmm. Right.
And you see, there are different types of experts. There is a chemical analyst, there's a ballistic expert, there's a post-mortem conducting doctor, right? Those are the basic experts that we need, right?
Hmm.
uh, and now you need somebody for bone ossification test. You need somebody to check viscera. You need somebody to find out whether there was a poison. Homicide may be committed, or death may be caused by different means. For somebody, you need some sort of a handwriting expert, specimen expert. How do you get so many experts in India suddenly out of thin air in 6 months, when the law was only passed in December? Now it is being implemented in 1st of July. There's so much trouble which is going to be caused. And the best part, who is to foot the bill? State governments. So you see,
Right.
it's a law which sort of descends from the sky, and it is left to the state governments to implement it. The portions which will incur a lot of budgetary problems, that forensic expert will have to go to some sort of a laboratory to deliver his results. You may have central laboratories, but they are hopelessly overburdened and understaffed, and they don't even have the ways and means to deal with such complex investigations. So, and with the new timelines, I think it's going to only create a mess.
Right. It's bound to take a toll on our institutional infrastructure for sure. If we could now just move on to some of the substantive provisions of the new laws, which have garnered a lot of interest. So, while the Home Minister was introducing the new laws in the Parliament, he stated that the offence of sedition under 124A of the IPC has been repealed. However, the offence has actually been retained in the BNS with a new nomenclature and a more expansive definition. Section 152, which is the new provision, is categorized under offences against the state and makes reference to the sovereignty and integrity of India in its definition. Do these new additions make the law more draconian?
See, under the erstwhile definition of sedition, you would recollect that the Honorable Supreme Court of India had stayed the operation of that particular provision, calling it colonial, also
Correct.
saying that this was not required in this day and age of democracy. Which is why the Supreme Court of India had categorically restrained any government from registering a case under this provision. Now, what you have done by bringing out this new law is that you have just not used the word sedition, but put in every singular ingredient of sedition within it. And in fact, what has also been done is that there have been certain terms which are not judicially defined, which have now found their way into the definition. Say, with the erstwhile sedition law, there was a constitution bench decision of the Supreme Court which had an occasion to examine every word, whether it tantamounts to sedition or not, right? In fact, there was also a very interesting explanation which was there, explanation 1 to sedition, which says that any sort of criticism of the government, notwithstanding how harsh that criticism is, will
Right.
not amount to seditious activity. If you are genuinely criticizing the government, let's say on a policy matter, on a law that they have, passed without giving a thought, that will not amount to sedition, because you are not, say, going against the government of the day. You are saying that the law which has been made is bad, right? So that will not attract sedition. For sedition to be attracted, there has to be a clear intent to carry out an activity or an act of violence. Now that explanation, which was the first explanation to sedition, has been done away with.
Hmm.
In the new law, that explanation does not find any mention whatsoever. I think that's very, very wrong, because tomorrow, if somebody were to interpret this law and say that, look, that explanation is done away with, so today it may even bring any form of criticism against the government of the day to be, seditious, although the word used is not seditious. And second thing is that there are certain words which have not yet received any judicial determination. Right now, one of those words that I see in the definition is, um, one second, I'm just reading the provision.
Sure, sure, no worries.
Yes, subversive activities. Now,
Hmm.
what is or what is not a subversive activity is not defined, right? Since it is not judicially defined, there is no way that a person could be roped in uh, for a subversive activity. You recollect, Aratrika, there was a very interesting case that happened sometime after the death of a certain political leader, when two girls took to Facebook to express their anguish at why a particular city was brought to a halt, or why a particular state was brought to a halt. And they were booked under Section 66A of the Information Technology Act, which
Right.
used an equally vague concept: whoever causes anguish, or whoever causes displeasure. These words were struck down by the Honorable Supreme Court in Shreya Singhal versus Union of India. But the
Right.
Supreme Court said these are so vague that it will defeat the purpose of a criminal law. Criminal law, by very nature, is has to be certain. You must be capable of giving a specific meaning to the words, because if you don't give meaning to the words, the net result is that those words could be so liberally construed so that any specific investigating agency may arbitrarily use those words to put people in prison. And what is the net effect? People's life and liberty is curtailed. They are just thrown into prison, right? Therefore, if you are looking at this word itself may be held to be void for vagueness, because this word, subversive activities, has never received any form of interpretation.
Right. So there's a lot of scope for arbitrariness that we see.
Absolutely. So therefore, I think it is going. It may receive the same fate as 66 of the Information Technology Act. In fact, I
Right.
recollect the first time when this matter was argued, the honorable judges said, "How did it escape us? Why was it never brought to our notice? This word is so wrong at so many levels." So therefore, these substantive provisions also will, I think, attract the same vice.
Right. That actually brings me to another provision, which is Section 113 of the BNS, which does not really provide us with a new definition of terrorism. It merely adopts the definition of a terrorist act as outlined in Section 15 of the UAPA, that is the Unlawful Activities Prevention Act. So, what are the potential implications of terrorism for the first time being brought under the purview of the main penal code instead of falling under any special law? Also, the safeguards that we have under the UAPA, are they missing in the new laws?
Well, yes, in some sense, yes. Because what has happened is, you remember there's a Latin maxim for all the law students. It said generalia specialibus non derogant, right? When there is a general law and when there's a special law, right? Then it is the special law which will always override the general law. Now, if
General law.
you already have a special law under the Unlawful Activities Prevention Act, Section 15, which defines a terrorist act, one might wonder, why do you want to even bring it under the general law? Right, when there is a specialized law which already exists, right? Second thing is that there was certain definitional, the procedural requirements were very interesting, because under the special law, while a police officer can take custody up to 180 days of a person,
Hmm.
however, that sorry, up to 30 days instead of the 15-day police custody, a police officer could take 30 days police custody, but at the end of the 30th day, the police officer had to file an affidavit before the court, personal affidavit, showing why further custody is required. What is it that you need the person in police custody for? I'm not saying that the person is to be let off. What I'm saying is that there are two forms of custody: police custody and judicial custody. For
Right.
continued police custody, there were certain procedural safeguards. Now, if you
Hmm.
take the definition without taking the procedural safeguards, it may result into a lot of trouble. Second thing, if you look at the explanation of this provision really is a giveaway, because the explanation to section 113 clearly says one thing, which says that one second. Yeah, it is hereby declared that the officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the UAPA Act of 1967. Now, this explanation really is very important, because
Hmm.
here the discretion is left to the superintendent of police to decide whether the person has to be booked under UAPA or under this law. So the word "or" is very important. It is not that somebody will be booked under UAPA also as well as general law also, right?
Right.
So there, I think this explanation really would save this provision in that sense. So
Oh,
the inclusion may raise some concerns, but since the definition mirrors the definition under UAPA, I don't think that itself is going to cause a lot of problem. It is only the procedural safeguards which may cause some concern. However, since there is an explanation and the superintendent of police decides that I am
hmm.
not booking somebody under UAPA, but I'm most
Hmm.
certainly booking somebody under the general law,
Hmm.
then you have a problem.
Do you think the absence of the procedural safeguard in particular, that, under the UAPA, you need the sanction from the central government, which is absent here? So do you think
That
that could have an adverse effect
that
where
see
anybody
sanction
could be just
requirements,
put under the
you're right.
provision?
Sanction requirements, those sanction require, but you see, Aratrika, it's going to have, uh, you know, uh, to be extreme. I mean, if you look at the sanction requirements and if you look at the custody, for
Hmm.
sure, those were certain procedural safeguards which are absent under the general law. But
Hmm.
then, if you look at, say, bail, the section 45 requirement under the PMLA will now not be attracted, because a person will now seek bail under the ordinary criminal laws.
Right. Right.
See,
Right.
so therefore, one might want to argue from both sides and say, look, a balance in some way has been sort of brought in. But you are right, absolutely. To sometimes the process becomes the punishment. So if you are arresting somebody without the sanction, then that person may or may not grant bail and may be granted bail. So one really does not know. What I'm trying to emphasize here is there's a lot of uncertainty.
Right, of course. There is. So the other provision which has been talked about a lot is the fact that Section 377 of the erstwhile IPC has been omitted in the BNS. For our viewers, this particular provision was struck down by the Supreme Court in the case Navteej Singh Johar versus Union of India, to the extent that it criminalized consensual same-sex relations between adults. Mr. Saxena, do you think this vacuum leaves men and transgender persons without any legal remedy now against sexual offences? And also, can states maybe bring in amendments to rectify this anomaly if the union government does not reconsider?
Let me answer your second question first. Now that investigation, etc., are subject matters in concurrent list, states can amend a substantive law and bring in, uh, offenses or define offenses and make them punishable. Has it been done yet? No. It's too early because it's today itself the laws have been passed. Will the state governments do it? Ideally, yes. Because today, as things stand, if there is any form of non-consensual uh, sexual activity which has happened or which has taken place between a member of the LGBTQ community with uh, then they really have no redressal as things stand today. Uh, because what happens is, unless and until you define an offense, what exactly is an offense, you can't make it punishable. And if today in the statute book, which is the Bharatiya Nyaya Sanhita, there is absolutely no mention of this particular provision which was relatable to section 377 unnatural offenses, then absolutely there is no way that any person, even if he or she has been sexually assaulted, uh, will have no recourse whatsoever before a police station. If that person turns up to a police station, the the SHO will just look in the statute book and say, sorry, we can't help you because this act is no longer an offense. Now a state government may want to bring out such an make that act an offense, because the honorable Supreme Court also realized the difficulty and said, look, we are not going to strike it in its entirety as unconstitutional. We are going to read it down and we are going to say that this particular provision will be safeguarded only to the extent that it prohibits and prevents any form of non-consensual sexual activity which is taking place. In case there is a non-consensual sexual activity which is taking place, then this provision will kick in. You can register FIRs under this provision. So it is only consensual sexual activities which were brought out of this particular provision. Sorry, Arathika, you are muted.
Can you hear me now?
Yeah.
In fact, my colleague today reported in the Hindu, Vijayata, saying that police officials are actually being asked to invoke allied sections under the BNS, such as wrongful confinement or physical hurt, in case they receive such complaints from transgender persons.
See,
So we'll
many
have
a
to
time
wait.
many a times you may not uh, be under confinement.
Right,
You see,
exactly.
somebody may just mix something in the drinks and thereafter do it somewhere and then just take off. Have those cases of date rape not taken place? Of course they have, right? So these are, you can't try to put Dr. Fix It to on a dam. If there's a crack, then you have to take other measures, not this.
Right, right. So moving on to some provisions of the BNSS now, which is the procedural code. The BNSS under section 173, subsection 3 mandates a preliminary inquiry to be conducted in every cognizable offense, which is punishable for 3 years or more, but less than 7 years. This essentially means that an FIR has to be mandatorily registered until the inquiry, sorry, this means that the FIR will not be mandatorily registered until the inquiry is complete. So, Mr. Saxena, what are the implications of this? And also, does this violate the Supreme Court's judgment in Lalita Kumari versus Government of Uttar Pradesh?
So pre 2014 era, we had an institutional corruption flowing through police stations. And by corruption, I just not mean monetary corruption. It was also political clout, phone calls coming to the police officers. A complainant was asked to run from pillar to post, and the police officers would refuse to register their FIR and conduct what you call a preliminary inquiry instead. Right? In Lalita Kumari, a constitution bench of 5 judges frowned upon this particular form or method which was employed by the police officers. They said, firstly, there is no preliminary inquiry which ever existed in CRPC. This is a this is a jugaad which was devised by you, and therefore you don't have to carry out any preliminary inquiry if there is a commission of cognizable offense. Now, as soon as you receive information as to the commission of cognizable offense, it is your duty to immediately register an FIR. You can't say, sorry, we have to commit or conduct a preliminary inquiry. Doing so will be dereliction of your duties. There's another problem. Preliminary inquiry, it's not that the Supreme Court has forbidden preliminary inquiries altogether. It says there are only very restrictive uh, places where there is scope for preliminary inquiries. They say for instance, there are very complex commercial disputes involved. There are civil proceedings of commercial nature going on, and suddenly somebody invokes a criminal, just to harass criminal case just to harass a party. In those cases, you can conduct preliminary inquiry. Second, in matrimonial disputes, which are essentially, between a husband and wife, and the wife has roped in everybody in the husband's family, is an severe, right? Case where there is an actual physical harm which has been meted out to the wife. Those cases are ones where you can explore the possibility of preliminary inquiries. But these offenses, let's say offenses which are ranging between 3 to 7 years under the Bharatiya Nyaya Sanhita, are total of 98 offenses. They also include grievous hurt. They also include acid attack. They also include this new version of sedition. So, in all of these particular 98 offenses, you are left to the discretion of the police officer whether or not he thinks that a preliminary inquiry has to be conducted or an FIR has to be registered. This is completely against the ratio of the judgment of the Supreme Court in Lalita Kumari, which clearly said that if the information discloses commission of cognizable offense, it is not open for the police officer to say anything. He has to register the FIR. It is only thereafter that the police officer will find out whether the ingredients are made out or not. Secondly, if the ingredients are made out, you can always file a charge sheet or a closure report, as the case may be. If the ingredients are not made out, then closure. If they are, then charge sheet. It is the discretion of the judge who will then see prima facie whether the ingredients of the offense are satisfied or not, and thereafter proceed to frame charges. Now, what has happened here is prima facie satisfaction has been given to the police officer, which is to say a judicial function as to whether the ingredients are made out or not for the purposes of conducting investigation, have now been given, are now conferred on a police officer. So this is really giving police officer too much power and too much discretion, and this is what causes a lot of trouble. And now look at it from the standpoint of an accused. As an accused, if an FIR was registered and the offense was between 3 years to 7 years, he had the benefit of Anish Kumar. He could not have been arrested. He had to be first given a notice to join investigation under section 41A of CRPC. Now here is a stage where no FIR is registered. The police is only conducting preliminary inquiry. He can detain the person. The accused does not even know why he's being called up. He is not told whether he is an accused or he's a witness, or he is, his status is not known. So therefore, this particular accused would, be at the grace of the station house officer.
Right. So, a lot which can be misused by the police authorities. So, we again have to wait and see how this plays out. Uh, Moving on to the last question for the evening, I'll make a reference to a provision which you referred to early on in the discussion, and a provision in particular which has been heavily criticized by experts, which is Section 187 of the BNSS. The provision allows an accused person to be remanded to police custody beyond the initial 15 days of arrest. So, the prescribed 15-day period of police custody can now be an aggregate of shorter periods of custody sought over the entire period of investigation lasting 60 or 90 days depending on the nature of the offense. So, Mr. Saxena, if you could please explain for our viewers the potential ramifications of such a provision on the rights of an accused.
See, under section 167(2) of CRPC, which was the earlier offense, there was a specific procedural safeguard which said that police custody can never exceed 15 days. Now, what has happened under the new law is that this proviso, which says not being police custody and 15 days, has been omitted under the new law. Now, the new law says that custody which may extend up to 60 days or 90 days. Earlier, there was a distinction between police custody and judicial custody. When you say police custody could only mean that custody which was for the first 15 days of registration of an FIR. And that is really when you would see in all, you would have covered it in all of your news channels when they say police remand is being sought. Police remand is usually being sought by the police officers to carry out custodial interrogation of the accused. Now, their chances of some sort of untoward things to happen to an accused cannot be ruled out in police custody, which what is constitutionally called police excesses, right? So forms of torture, etc., may be employed to a person, which is why you see many a times they have made various procedural safeguards. Carry out their medical examination before you take them, and thereafter you produce them physically before the magistrate, so that the magistrate can see whether the person exactly has been hampered or not, or he has been injured or not, right? So all those things are now done away with, because now police custody can be extended for a duration of 60 days or 90 days, because the proviso under section 167 subclause 2, which said that period not being police custody, has now been omitted under the new law. So this omission is very critical. Here you have not included, or you have not incorporated something new, you have omitted. This particular omission now means that the police now gets carte blanche powers to hold somebody in custody either for breaks of 5 days, 10 days, 15 days, 20 days, ranging up to 60 days or up to 90 days. And that really is the problem in this provision. Of course, why are we saying it is problematic is because it has a direct bearing on somebody's life and personal liberty. We all know it's an open secret what goes inside police lockups, right? And these are things that even the Supreme Court and the High Court entertain habeas corpus petitions on Article 32 and 226 petitions if there have been any forms of torture, etc., under police custody. This omission is in fact institutionalizing the practice of seeking police custody way beyond the time, which is way beyond 15 days. And add to it the problem that now the accused does not have to be brought physically before the magistrate so that the magistrate can look at the injuries. The accused now can be produced digitally also. So imagine you are looking at any accused on a video camera. Can you ascertain whether the accused is injured or not? So these are really the problems that one would face when these laws would you know uh, be tested on the anvil of constitutionality.
Right. Does this also mean that getting bail will get more difficult because generally trial courts entertain bail applications only after the remand hearings are over? So, if the police custody is extended, will getting bail become more difficult?
That's a likely result, of course, because if the police is able to see, it's a double-edged sword. It's or sorry, more than it's a catch 22 situation rather.
Hmm.
If the police's prayer to seek police custody is allowed, then that naturally means bail denied, right?
Right.
And if the police is able to establish that we need more time to interrogate the person, then that person's bail application will be dismissed.
Right.
In fact, one of the grounds for granting bail is that he is no longer or she is no longer needed in police custody for the purpose of
Exactly.
interrogation. Every evidence that had to be collected has been collected.
Right. Thank you so much for joining us today, Mr. Saxena. I'm sure this discussion will be very insightful for all our viewers. And our viewers, thank you so much for joining in this session. We also have two more videos on the new criminal laws, the link to which have been given in the video description. Please do check it out. Thank you so much for joining us today.
Thank you so much, Aratrika. Thank you.